Morning, everybody. Welcome to our webinar today on selling a business, how to undertake due diligence. I am Anthony Satti. I'm a practice group leader here at LegalVision, and I am joined by Warrick Oakes, a director of the corporate advisory group at HLB Mann Judd, who is a partner of LegalVision.
Morning, everyone.
So before we begin, you'll be emailed the webinar recording and slides today. If you have any questions, please submit them in the chat box. And we'd ask you to kindly complete the survey after the end of the webinar. Webinar attendees today are eligible to receive a complimentary consultation to discuss how LegalVision can assist your business. To book the consultation, just leave your contact details in the survey that appears at the end of the webinar. So today, what will we be canvassing? We'll be going through some high-level information about what due diligence is and its process, NDAs, and the link to the sales agreements, and then we'll go through some very specific subject matters that you'll need to go through, or one would go through as sellers as part of the due diligence process, and we'll end with some considerations of how misleading and deceptive conduct might apply to due diligence and conducting due diligence on the potential purchaser of one's business or target company. And we'll end out with some Q&A. So what is due diligence? Which we also in the industry often call DD, and throughout the presentation you might hear Warrick and I call it DD. What is it? It's basically a process of verification, investigation, or an audit by the buyer of a potential target business or a target company to confirm all the relevant facts and financial information that the seller discloses. It usually involves inspecting business records, physical assets, and even meeting with staff of the target business. The whole purpose of due diligence is to make sure that, from the buyer's perspective, they're making an informed decision about the transaction they're about to enter into. They're making sure that they know what they're about to pay for, and potentially highlighting issues that they either need to deal with in the sales agreements, or they're issues that are so grave or so serious that potentially they need to consider walking away from the deal. I'll hand over to Warrick.
So thank you, Anthony. So what's the process? So there are a number of steps involved with any transaction. It's also very important to provide the right information at the right time. The first step is to enter into a non-disclosure agreement, and then which will allow some access to some initial information that will provide a prospective buyer with enough of an overview of the business to enable them to submit either a term sheet or other documents such as a heads of agreement. If agreeable, full due diligence will commence, which normally runs for a period of around 2 months. And during this time, a sales agreement will also be negotiated. The sales agreement will then be entered into, with the next milestone being completion or settlement a few months after it all starts. As to who's involved, on the next slide, please. Great. So there's a few examples there on screen of the parties who are involved in a transaction, and often includes directors, senior managers and shareholders, professionals such as ourselves, including lawyers, accountants, corporate advisors and other specialists in HR or IT, for example. The intention is obviously for an efficient and smooth process to be run. So utilizing experts at the right time helps keep the transaction on track. And it's also important to remember that a transaction is distracting to anyone who's involved in the process. So it's important it doesn't interfere with the day-to-day running of the business, which needs to remain the priority. So on the next slide, we'll talk about how the process is run. So typically when the due diligence phase begins, the buyer will typically submit a request for information, which forms the basis for contents in the data room. So the seller doesn't have to wait for a list to come through though, and the strategy to maximize value is to be prepared for what they may ask for. The data room is basically a virtual filing system and acts as a central area for all information storage and information flow. It's important as it serves as a central repository for what's disclosed as part of a transaction, And Anthony will also go through this in a little bit more later on. A key feature of the virtual data room is the question and answer section. So buyers ask questions which are responded to by the seller. Supporting documents are then loaded and referenced within the data room here, and then a copy is also included in the appendix to any sales agreement. So on the next slide, we've got a few of the areas to prepare for.
Yeah, so thanks, Warrick. So as you're going through the due diligence process, what are the documents and information that you need to prepare? Well, what we've put in this on the slide there, the various areas that due diligence touches upon. So it will involve uploading company documents or corporate governance documents, minutes, constitutions, potentially trust deeds. Information about employees, about plant and equipment, material contracts, certain searches against the company and its shareholders, information about any business licenses or other authorities that the business currently holds, claims and disputes about maybe the businesses or target companies been involved in with third-party suppliers or customers or even employees for that matter, and a full reference of the IP. As we go through this presentation, we'll actually focus on a couple of those key areas and what you need to be looking out for. In the next slide, I wanted to kind of touch on a pretty important first step within the due diligence process, which is making sure as a seller you have a confidentiality agreement, or also known as a non-disclosure agreement, in place with the potential buyer or buyers before you go off and disclose information to them about your business. This is, particularly even more important where maybe a competitor is involved in potentially acquiring your business. Naturally, you don't want to, hand over all that sensitive information about your clients and about your IP, your know-how, your sales, etc., without some form of legal protection in place. As a seller, what are some of the key terms you want to see? I would want to see my clients to have in an NDA. Obviously, it's about making sure that it's capturing all the information that's part of the negotiations and information that's been disclosed in the data room, that the disclosure is only limited to certain persons by that seller. So usually that's their advisors and employees who genuinely need to know for the purpose of this potential transaction. Usually trying to include some sort of indemnity in your favour as a seller, so that if they breach, it's an easier path to sue for any damages that result from that breach of confidentiality or breach of contract. Usually requiring them to have, implement controls and technical safeguards to protect your data. It's usually the case also you're at this stage giving that information on a no warranty basis or an as-is basis, and you'll include some provisions around how that information needs to be returned or destroyed, particularly if the transaction doesn't progress. And sometimes you might include some restraints, potentially around not soliciting clients or not soliciting employees, again, depending on how much information is being disclosed or intended to be disclosed to the potential buyer. In the next slide, what's important is to put due diligence in the context, the greater context of the negotiation of the sale agreement. Now, one of the key features of your sale agreement is that there are warranties that you as a seller give the buyer about the target business and the target company. So they might be things like that the shares that you're selling to the potential buyer are free of any encumbrances, or that the target company hasn't been involved in any litigation in the last 3 years, that the business assets are in good working order. Things of that type of nature. Then if the seller breaches those warranties, i.e. that they after completion become untrue, then the buyer will have some sort of claim against the seller for any damages that flow from that breach of warranty, and they might also have an indemnity in their favour under the sale agreement for in respect of breaches of those warranties. So A key way in which the seller limits that exposure to damages and limits those exposure to breaches of those express warranties is to essentially disclose against them. So basically that means that there's a provision usually in the sale agreement that says the sellers won't be liable for a breach of warranty claim to the extent that the due diligence materials given to the buyer and their representatives, set out certain information. From the buyer's perspective, also kind of what's the link to the sales agreement? As the buyer goes through the due diligence process, it might highlight certain issues that either need to be dealt with in the sale agreement as conditions to completion, or just simply completion obligations, or potentially they're matters that the buyer require as specific indemnities from the seller. So, for example, it could be that through the process of better understanding the sales figures and employees, the buyer comes to understand that there are a select number of key staff in the business that are responsible for a large portion of the sales, and therefore it's in their interest to want to make sure that those key staff are hired on and continue on in the business. And it might be that they then therefore ask for, in the sale agreement, as a condition precedent, that those key staff sign employment agreements with them. And I'll hand over to Warrick as to talk about preparing financial reports and tax.
Great. So a simple way to maximize value in a transaction is obviously just to be prepared. It helps present the business in its best light, and you can address all those potential issues before they're picked up by a buyer. What the due diligence allows us to do, therefore, is to present the information on a consistent basis, which will ultimately tie through directly to the purchase price calculations. Being up to date with lodgements and so on is also a demonstration of the business being in its best light. For a buyer, the purpose of financial due diligence is to determine a normalized earning position on a consistent basis, and this is achieved by applying a consistent methodology on all months presented, so that's the monthly management accounts, as well as applying the accounting standards the same way across reporting periods or other management points. Management accounts also don't need to follow the accounting standards, so having a reconciliation to year-end financials will help achieve your consistency. Forecasts are very important because they're likely to be used as the yardstick to measure performance and likely tied to an earnout. Again, consistency is key to what's been presented. Forecasts do need to be achievable, as you may have significant value tied in the outcome of future results.
Thanks, Warrick. So another key area that we prepare for the process is sorry, is there an echo? Yeah, Warrick, can you hear echo?
No, you're okay.
No?
No, you're okay.
Yeah, ladies saying that might just pause there for a second.
Sure.
Apologies, everybody. Another area that employees and contractors. Sorry, there is a.
Just give Anthony a few minutes there just to sort that out. Sorry, can't hear you there. I can hear you now. Yeah, that's fine.
Perfect. It's still potentially okay. So an area that the list of employees and contractors, usually a buyer will want to see full details in respect of all the employees and potential contractors that they might be taking on. So they want to see details relating to salary and payments, and most importantly, accrued entitlements, particularly because that links directly into the purchase price, potentially as an adjustment to the purchase price to deal with how the buyer and the seller are assuming liabilities or those employee liabilities. A buyer will want to know whether there's been any existing or historical claims or disputes by employees. They'll want to see copies of all the employment agreements and contractors, particularly to see what terms and conditions have been in place, because it's normally the case that if there will be a requirement of the sale agreement that they employ them on similar or substantially similar terms. They'll want to know whether there are any relevant awards or enterprise agreements or collective bargaining agreements in place, and potentially whether there's any union involvement for that particular business. And a lot of that has to do, again, with not only adjustments to the purchase price, but risks that the buyer needs to assess and potentially deal with in the agreement. Another key area on the next slide that we would prepare as a seller in the due diligence process is intellectual property. So again, the buyer will want to see full list of what intellectual property, whether registered and unregistered, the business maintains. For a lot of businesses, the IP is the most valuable asset to the business. So in preparing for due diligence and preparing for the sale, questions that you need to ask yourself as a seller is, for marks or particular IP that can be registered, have they been registered? Have you registered a trademark? Is there potentially third parties out there that are infringing your brand? Then you need to make sure that you go and do something in order to protect the value of your brand. If you've been maybe developing IP, like for example, software through third-party contractors, do you own that IP? Have you entered into agreements with those contractors which make sure that that IP is assigned to you and that you own all rights into it? And have you scanned the market for whether you yourself have been infringing somebody else's IP through your brand or through your product? All issues that a buyer will want to kind of flesh out during DD and assuming you're attempting to buy your business. Now, another key kind of area in due diligence is material contracts. So, some examples we put on the slide there. Key contracts to property leases and any licenses, software agreements, shareholder agreements, potentially customer contracts, particularly with those with key clients. Equipment licenses or equipment leases, IP licenses, and kind of just generally other supplier contracts that might be pivotal to the ongoing operation of the business, like manufacturing agreements or potentially distribution agreements. The key thing from the buyer's perspective in looking at those documents, depending on whether you're effecting an asset sale or a company sale, is that they're looking out for, do those agreements have assignment clauses or change of control clauses and therefore require third-party consents? Are there any terms in those documents that are unusual or not at arm's length or potentially onerous? And generally, are those provisions kind of in order? Are those contracts validly executed contracts? And naturally, they'll want to see copies of all of these documents up in the data room. Now, on the next slide, we kind of deal with an interesting subject matter, which is misleading and deceptive conduct. Now, a lot of you might assume that misleading deceptive conduct, which lives in the Australian consumer law, is only a kind of end client issue. It's actually absolutely not. It is wide enough to also be applicable to a business sales scenario. And the key takeaway I would give to you before we go through this example case study is that trying to put limitations in the sale agreement won't necessarily help or save you. You can still be considered as having engaged in misleading and deceptive conduct and subject to damages. And that really came to light in this recent case, which happened at was determined at the end of last year. QVP Pharmacy. What did that involve? it was involving the sale of a pharmacy in Sydney's Queen Victoria building. The parties entered into a contract of sale. During negotiations, the vendor provided various financial documents to the purchaser, which the purchaser relied on in obtaining a valuation. After completion, essentially, it kind of came to light that a lot of those financial documents were materially incorrect and inflated the numbers in a lot of respects. So the purchaser brought a claim against them for misleading and deceptive conduct, and essentially argued that if it wasn't for those misleading financial statements and information, that it wouldn't have purchased the business. Now, the seller in this instance tried to argue that the financial statements and information were unaudited and that they had relied on their accountant. And most importantly, they were trying to rely on some provisions in the agreement, mainly the fact that they didn't give an express warranty about the accuracy of those financial information. And there was clauses within the contract that said that the purchaser acknowledged that it relied on its own inspections of the business. Ultimately, the court looked at all of this and found in favour of the purchaser, awarding them $1 million in damages, which was reflective of the reduced value of the business. For the court basically determined that it made no difference that it was of no consequence that the accountant was involved. The seller should have known and that should have made sure that the information was correct and knew that the purchaser would rely on it. And just because the clause in the sales contract referred to the purchaser, having a reliance on its own inquiries, didn't help the seller in this instance at all. So a fair warning on making sure that when you're doing due diligence as a seller, you're being honest, you're putting up information that is materially correct, and as a side note, it's worth mentioning that in a lot of sales agreements, there will be also a specific warranty that you as a seller give the buyer that the information that you've disclosed in the disclosure materials is materially, and factually correct. I'll hand over to Warrick.
So on the other side of the fence is if you're a seller and you've been bought out, or there's been a merger transaction, you may want to know a little bit about the person or the business you're about to undertake the deal with. This could include knowing about any potential risks to make sure they're manageable to you, and also in the case of a deferred payment or earn-out as we call it, just knowing that the buyer has got enough assets and is financially sound so they can pay you any of those amounts which are deferred. If the sale also involves you staying on in the business as an employee, within a management role, for example, you may just want to do some research to make sure the buyer is the right fit. We also find that owners obviously really care about their staff, and but all those relationships that they've built up over the years at the helm, as well as the brand. So they want to generally know that the buyer they are selling to will treat their staff properly, and their brand and business will continue on in good hands. As advisors, we're able to obviously help you with that process. We can run searches, including ASIC, PPS, bankruptcy litigation searches, just to gain an understanding of who the underlying ownership is, and do they have any interests that may be registered against them that might impact any of your security interests if you do stay on. And your advisors can also obviously help make sense of any financial information, other things like constitutional documents and company constitution, shareholder agreements, and trust deeds, just so you know the full picture before entering into any deal.
Thanks so much, Warrick. That's the end of our presentation, everyone. Sorry for the technical difficulties before. You're actually all able to download our How to Sell Your Business publication by accessing the handout section in the webinar panel. Letting everybody know that coming up is our Tenants Guide to Commercial and Retail Lease Disputes by our property team here at LV, which is on Thursday, the 18th of April at 11 AM. And you can register at the website link shown on the screen. Now, we're going to answer your questions shortly. While you submit them, we'll just take a minute to tell you about our LV membership. LegalVision's membership is a cost-effective alternative to the expensive hourly rates experienced with other law firms. For an affordable monthly fee, you receive cost certainty and an all-inclusive legal services, including unlimited document reviews, including drafting, amending and reviewing business contracts and commercial leases. It includes unlimited advice consultations with our team of 100+ specialist lawyers, including business structuring, employment disputes and more, and unlimited domestic trademark registration. LegalVision's membership is like having your own internal legal counsel. We'll take care of all the business as usual legal work so you can focus on actually running your business and making some money. And if you're an in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how our membership can help you and your business, request a free consultation when the survey appears at the end of this webinar.
Thanks, Anthony. And also feel free to get in touch should you have any questions about what you've seen today or you're thinking of selling or buying a business. I'm always happy to take a call and offer some assistance for any transaction-related questions. My details are on screen, so please feel free to reach out. Thank you.
Thanks, Warrick. I think we'll deal with some of the questions that have come up in the live chat box, which you can all still submit. Then there was a couple of questions that were lodged before the webinar began. One of them was a larger company wants to purchase our small business. The buyer has asked me to formulate a legal offer. Is it usual practice that the vendor presents a contract? I think, from my perspective, it is always good practice, whether you're the smaller business or the larger business, for the vendor to be the one that dictates the terms of the sale agreement as much as you can, and that you would want to be or have the pen and draft that up at first instance to try and make sure that you're putting in as many protections as you can for yourself, and then naturally negotiate with the buyer. I guess downwards, you want to make sure that you put your best foot forward.
Yeah, I'd also like to add that within the legal offer documentation, there's obviously the share purchase agreement, but there's often a term sheet or heads of agreement, which can be entered into a little bit before that. So it's obviously not as detailed, but you can actually deal with a lot of the negotiable points in there so that you know that, whether or not the deal will be able to proceed.
Yeah, for sure. Another question was, as part of due diligence, when can you find competent valuers to provide a valuation on the business that is being sold? Well, I can refer you straight to Warrick and his team on that one.
Yeah, thanks, Anthony. Yeah, so most chartered accounting firms, larger ones, will have a dedicated valuations expert or team within the practice. Feel free to reach out and we can certainly help you out.
There was another question that's come through. When might you use a heads of agreement, which kind of Warrick touched on. Certainly, I think if the value in a heads of agreement is that it really sets out between the parties the key commercial terms that they are agreeing upon for the deal before they go through the due diligence process and before they go through the process of negotiating the sales agreement. Kind of helps streamline things. Heads of agreements are usually drafted on a non-binding basis, other than for a couple of key provisions like an exclusivity clause and potentially an additional confidentiality clause, but otherwise are non-binding documents.
Yeah, I find it's a very useful tool for negotiating the nitty-gritty. So what I'm talking about is any purchase price adjustments. We include things there about working capital, making sure things are allocated either as working capital or debt, just so everyone knows what the adjustments will be, come completion.
I think that kind of might be it for questions that we're able to deal with in this call. So I might just move on to the next slide. By all means, everybody, we implore you, please request a complimentary consultation. After the webinar ends, a survey will pop up
We'd really appreciate it if you can complete it. It's a 30-second survey, and please include all your contact details, and a member of our team will reach out to you. Thank you so much, everyone, for attending the webinar today, and thank you, Warrick, for joining and presenting with me. I hope you found it informative, and we'll see you next time.
Thank you, everyone.